buying or selling property, it's not just a transaction, is it?
Yeah.
It's one of the biggest emotional and financial commitments most of us make.
Huge. Yeah.
Filled with excitement, anticipation, maybe a bit of stress about all the paperwork, and let's be honest, sometimes some real surprises pop up.
Exactly. That thrill of a new home or a good sale is great. But yeah, those hidden details, they can definitely turn excitement into a headache fast.
Well, today on The Deep Dive, we are trying to cut through some of that uncertainty. We're diving deep into a really significant change that's about to transform property sales right here in Queensland, the new seller disclosure scheme.
This scheme, which kicks off very soon, it's really all about bringing much more clarity, more transparency to property deals.
Okay.
It's designed to arm buyers with crucial info up front and, just as important, to clarify what sellers have to disclose. Think of it as a shortcut, maybe, to understanding what you really need to know when you're buying or selling freehold land in Queensland.
And to make sure we get this right, we've gone straight to the source material. Our deep dive today is based entirely on the official Guide to the Seller Disclosure Scheme from the Queensland Government.
Yep, that's the guide designed for everyone, sellers, buyers, agents, to help navigate this new landscape.
So our mission today is to unpack this new scheme, highlight what it actually means for you, whether you're buying or selling, and pinpoint the really crucial details you need to know, especially with that commencement date getting closer, August 1st, 2025.
That date is key.
Okay, let's peel back the layers then. Where do we start?
So the first thing, absolutely critical, is that start date, August 1st, 2025.
Right.
The scheme officially commences then, and it applies to any sales contracts entered into on or after that date. That means when both buyer and seller sign.
Okay, so it's a hard line in the sand. What was the main problem this new scheme is trying to fix?
Fundamentally, it's about shifting where the burden of finding information lies. You know, before, buyers often had to do a lot of digging, expensive, time-consuming digging.
Yeah, I've heard stories.
Right. This scheme flips that. It clarifies what sellers must disclose, sets up a clear process, and gives buyers valuable information up front. It's about making things, well, fairer.
That makes a lot of sense. So who exactly does this affect? Is it just houses or is it broader?
Oh, it's broad. Definitely broad. It applies to all contracts for sale of freehold land.
All freeholds.
Yep. So houses, units, townhouses, sure, but also commercial places like warehouses, offices. And it covers all the usual ways property is sold: treaty, tender, auction.
Even auctions.
Even auctions and options for sale, too. And a really crucial point, you can't just agree to skip these disclosure rules unless the scheme specifically allows it.
Right, so no side deals to avoid disclosure.
Exactly. It's not optional.
That sounds like a massive shift.
Yeah.
But are there situations where it doesn't apply? Maybe some surprising exceptions. This is where it gets interesting.
Yes, there are some important exceptions to know. For instance, really high-value sales over $10 million, including GST, if the buyer agrees to waive the requirement.
Okay, so mega deals might get a pass with agreement.
And also, if the buyer and seller are related, like family members, and they both agree to waive it.
Makes sense for family transactions. What else?
Sales to government bodies, state, commonwealth, local councils usually exempt. Also, some specific cases like a council selling land to recover rates or the state selling to a long-term tenant, but only if they give specific notice that disclosure isn't required.
Okay, government stuff is generally out. Any other twists?
Definitely. Sales between existing co-owners or just to adjust a boundary line between neighbors, they're exempt.
Ah, okay.
Also, sales happening because of court orders, enforcement warrants, or family law settlements, and maybe surprisingly, sales resulting from the death of an owner.
Really? After someone passes away?
Yes. And finally, if the sale is just fulfilling a pre-existing option where disclosure was already done when the option was granted.
Wow, that's quite a list of situations where the rules don't apply. So what's the key advice for sellers navigating this?
Strongest advice, don't assume. Ever. Even if you think your situation fits an exception, get independent legal advice to confirm it. The risk of getting it wrong is just too high.
Sound advice.
Huh.
Okay, let's get to the core of it. What exactly must sellers provide now?
Okay, so before the buyer signs anything, the seller must provide two core things. First, a seller disclosure statement, the SDS, in the official approved form.
Right.
And second, any applicable prescribed certificates. These are mandatory, no ifs or buts.
So it's formal, Required info exchange. Sure. Tell us more about this seller disclosure statement, the SDS. What's in it?
Right, the SDS. It has to be that official form from the government website. Can be paper or electronic, but must be signed by the seller. E-signatures are fine.
Okay.
And this is vital. The info must be true at the time it's given. But, and this is a big but for buyers, the seller has no ongoing duty under the scheme to update it after giving it to the buyer.
Oh, that's critical. So the info is a snapshot in time. No updates needed later. What does the SDS actually cover? The nitty-gritty.
It's pretty comprehensive. Starts with the basics. Part 1 is seller and property details, names, address, lot description, and importantly, whether it's part of a community title scheme or a BUGTA scheme.
What's BUGTA again?
Sorry, Body Corporate and Community Management Act. Basically, it tells you if it's a unit or townhouse complex with shared property and rules.
Got it. So that first part sets the scene. Where does it get more complex?
Part 2. Title details, encumbrances, and tenancies. It says if a title search and survey plan are provided. But the really interesting bit here is disclosure of unregistered encumbrances.
Unregistered encumbrances.
Yeah.
That sounds like exactly the kind of hidden issue this scheme targets. Like what?
Exactly. These are things not on the title but still affect the land and stick with it after sale. Like an unregistered lease, its terms, rent, bond, renewals must be disclosed.
Okay.
Or even informal oral agreements. You know, maybe you let your neighbor use part of your driveway for access and they help with maintenance. That kind of verbal deal now needs to be disclosed.
Wow, even an oral agreement. That's digging deep.
It is. And also statutory encumbrances, rights created by law for things like power lines, drains, sewers, often for infrastructure. They might not be on the title, but can definitely impact how you use the land. Can also be charges for unpaid government money.
Okay.
And if there was a residential tenant in the last year, the date of the last rent increase needs to be stated. Useful for investors.
That's way more detail than buyers often got easily before. What about land use, planning, environmental stuff? That's part 3.
Yeah, part 3 covers property zoning. Crucially, it includes any government notice about transport infrastructure proposals, plans for roads, rail, etc., on or affecting the lot.
So you'd know if a highway might be coming through your backyard.
Potentially, yes, or if the block size might change. Also, any notice of intention to resume, that's the very first formal step in compulsory government acquisition. Knowing that early is critical.
Absolutely. What else in this section?
Info on contaminated land. Is it on the register? Are there environmental protection notices, like cleanup orders? Plus tree disputes or orders and heritage listings. Basically flagging government plans or environmental issues.
Moving on to the actual buildings and structures. Part 4. What's covered there?
Presence of a pool, either on the lot or shared, which triggers needing separate pool safety certificates. Also, unlicensed building work done under an owner-builder permit in the last 6 years.
Unlicensed building work,
Mm-hmm.
like DIY stuff. What's the significance for a buyer?
Exactly, like DIY renovations. It's important because disclosing this means the seller gives a contractual warranty that the work was done properly.
So there's some protection there.
Yes. This part also covers any unresolved show cause or enforcement notices, things about dangerous or dilapidated buildings or development offenses. These could mean mandatory repair costs for the buyer down the track.
You definitely don't want to inherit those kinds of problems.
No way. And it also includes any other notice or order still in effect that requires work or money spent. Could be a QC hat order about a fence, a council cleanup notice, even a tenant breach notice.
Okay, almost there. Part 5 is rates and water.
Yep. Straightforward but essential. Total rates and charges from the last notice and water service charges from the last notice or an estimate. Helps with budgeting.
And finally, Part 6 for those shared properties.
Community titles schemes and BUGTA schemes. Just confirms if the lot is part of one and if the body corporate certificate and the community management statement, CMS, are provided. Vital for understanding ongoing fees and rules.
That is a lot of information sellers must provide.
Yeah.
But flipping it around, what are sellers not required to disclose under this scheme? This feels like another crucial point for buyers.
It really is, because due diligence isn't dead. The scheme does not require sellers to disclose past flooding or natural hazard history.
Really, no flood history disclosure required.
Correct. Nor the structural soundness of buildings or pest infestations like termites.
Wow. So the house could have serious structural issues or termites, and there's no mandatory disclosure under this scheme. That's a huge heads up for buyers.
It is. Also not required. Current or historical use, past building approvals, planning law limits on use, services connected, or the presence of asbestos.
So the big takeaway here, This scheme is a massive step for transparency, but it doesn't cover everything. Buyers, you still need to do your own homework, your own inspections and searches, especially for things like structure, pests, and flooding. Don't assume the SDS tells you the whole story.
Absolutely critical point. Now, beyond the SDS, sellers also have to provide those prescribed certificates. Think of them as the official documents backing up some of the SDS statements.
The essential attachments, basically.
Kind of, but they don't have to be physically attached to the SDS. They just need to be given before the buyer signs the contract. They stand as separate required documents.
Got it. What sorts of certificates are we talking about?
Okay, first, titles and details. You need a current title search and a copy of the survey plan.
Standard stuff, usually.
Yes. Then for land use, planning, and environment, copies of any of those official notices we mentioned, transport proposals, intention to resume, environmental protection notices for contamination or cleanups, tree orders.
So the actual notice document itself.
Correct. For buildings and structures, pool compliance certificates for every relevant pool or a notice saying there isn't one, that notice about any unlicensed building work, and copies of any active show, cause, or enforcement notices, like for a dodgy building or development breach.
Active being the key word there.
Yes, unresolved issues. And similarly, any other active notice or order demanding work or money be spent on the property, like that fence order from QSAT or a council cleanup demand.
Right. And for units and townhouses again, the community schemes.
For community title schemes and BUGTA schemes. If it's a community title scheme, you need a copy of the latest community management statement, CMS, and a body corporate certificate. If it's the older BGTA scheme, just the body corporate certificate.
And these give you the lowdown on the body corporate's health and rules.
Exactly. Fees, insurance, sinking fund, disputes, bylaws, it's all in there, or should be.
How do sellers get these? Especially the body corporate ones.
They get titles docs from Titles Queensland. For body corporate certificates and CMS, they request them from the body corporate manager or committee. There are set fees and time frames, like the body corporate has 5 business days to provide it, though there's usually a faster express option for a higher fee.
Good to know there are time frames. But what if, say, the body corporate records are a mess or there's no committee? Can a certificate just not be obtained?
Good question. The scheme anticipates that. If a certificate genuinely can't be obtained for specific reasons laid out in the Act, like records missing or destroyed, no functional committee, the seller doesn't just get off scot-free. They have to provide a formal explanatory statement detailing why it couldn't be obtained.
So transparency is still the goal, even if the document itself isn't available.
Precisely.
Okay, practicalities. How do these documents, the SDS and the certificates, actually get from the seller to the buyer? What are the legal delivery methods?
Several ways. Good old personal delivery works. Leaving it at or posting it to their home or business address. Though with post, there's a legal assumption it's received 7 business days later unless you can prove it arrived sooner.
Right. Postage delays need factoring in. What about digital? Everyone uses email.
Yeah, digital is covered. A seller can give a physical document that just has an electronic link to view everything online, but they must offer a hard copy if the buyer asks.
Okay.
Or if the buyer consents beforehand, the seller can email them directly, either attaching the documents, putting the info in the email body, or providing that electronic link again.
And when is an email considered received? When it hits the inbox?
Legally, it's when the electronic communication is capable of being retrieved by the buyer at the address they provided. So basically, once it's accessible in their inbox.
The key is the buyer must have access before they sign. Now, how does this work for auctions? They're so fast-paced.
Yeah, auctions have their own rhythm. The scheme definitely applies, but the timing is different because signing happens right there at the end. If a buyer registers before the auction starts, the seller has to give them all the disclosure documents before the auction kicks off. Gives them time to review.
Makes sense. But what if someone rocks up late, registers during the auction?
In that case, for an in-person auction, the seller has to make sure the documents are physically displayed, maybe on a table, or provide a link with the option for a hard copy. For online auctions, the documents must be made available electronically through the same platform right from the start until the auction ends.
So access needs to be continuous during the auction for latecomers.
That's the idea. Ensures everyone has the chance to see the info.
Okay, now for the really powerful part for buyers. Termination rights. When can you, as a buyer, legally pull out of the deal after signing based on this scheme?
This is a big one. A buyer can terminate the contract anytime before settlement if one of 2 key things happens. First, pretty straightforward. If the seller simply failed to give you the SDS or a required prescribed certificate before you signed, complete noncompliance.
Okay, failure to provide is grounds. What's the second trigger?
The second is if the SDS, or a certificate you did receive, contains an inaccuracy or omission about a material matter affecting the property. But there are conditions.
Which are?
You also have to prove you were unaware of the true situation when you signed, and crucially, that you wouldn't have signed the contract if you had known the correct facts. It has to be genuinely significant.
A material matter. That sounds important. But is there anything specifically excluded from being material for termination? This sounds like a key nuance.
There is, and it surprises people. Information about rates and water services is explicitly not considered a material matter for these termination rights.
Wait, really? So if the rates figure is wrong in the disclosure, you can't terminate based on that alone under this scheme?
Correct. Under this specific scheme's termination rules, that inaccuracy isn't grounds to walk away. There might be other remedies, but not termination under this provision.
That's a really important detail. So if you do terminate validly under the scheme, what happens? Can you sue for damages caused by the inaccuracy?
Under the scheme, the only remedy provided is termination itself. You can't sue the seller for compensation under this particular law for the inaccuracy or omission that led to termination.
Just get your money back.
Yes. If you terminate, the seller must repay any deposit or other purchase money you've paid, plus any interest earned on it within 14 days. Sellers, however, should get legal advice as they might face liability under other laws.
Okay, so termination is the remedy within this scheme. Are there exceptions where this termination right doesn't apply, even if there seems to be a disclosure failure? Another twist.
Yes, another important interaction with other laws. If the seller's failure or inaccuracy is also a failure under a different act, then the consequences set out in that other act apply instead of this termination right.
Can you give an example? That sounds potentially confusing.
Okay, remember the unlicensed owner-builder work we talked about?
No, the DIY wall example.
Right. If the seller fails to give the required notice about that work, you actually don't get the right to terminate under this seller disclosure scheme. Instead, the QBCC Act kicks in.
And what does that say?
The QBCC Act says the seller is automatically taken to have given a contractual warranty that the work was done properly. So your remedy lies in enforcing that warranty, not terminating the whole contract under the disclosure scheme rules.
Ah, I see. So the takeaway is finding a disclosure issue after signing doesn't automatically mean you can terminate under this specific scheme. You need to understand if other laws override it or provide different remedies. Due diligence and legal advice remain key.
Exactly. It highlights how different pieces of legislation interact. Okay, finally, let's quickly cover the transitional provisions. How do we handle deals happening right around that August 1st start date?
Right, the changeover period. So remind us, the hard cutoff date is?
August 1st, 2025. The scheme only applies to contracts entered into meetings signed by both parties on or after that date. Anything fully signed before then is under the old system.
But what about that potential gray area you mentioned, where someone signs before and someone signs after?
This is the tricky bit. Let's say you, as a buyer, sign your offer the contract document on July 30th, 2025.
Okay.
But the seller doesn't sign it and complete the contract formation until August 1st or later. Because the contract is legally entered into on or after August 1st, the new seller disclosure scheme will apply to that contract.
Even though the buyer signed thinking the old rules applied.
Yes. That could catch people out.
That sounds like a recipe for confusion for sellers who thought they were done before the deadline. What's the practical advice there?
The safest approach for sellers in that situation is this. If you gave disclosure docs before August 1st, but the contract might only be fully signed after August 1st, those pre-August 1st documents might not be considered compliant under the new scheme.
So what should they do?
To be safe, they should really consider issuing a fresh contract document dated on or after August 1st, 2025, accompanied by the new required SDS and certificates for the buyer to sign then. It just avoids any arguments about whether disclosure was properly given under the correct scheme.
That's really practical, sensible advice for anyone doing deals around late July, early August 2025. Okay, so wrapping up, this new seller disclosure scheme is clearly a huge step for Queensland Property. It's aiming for much more transparency, getting crucial information out up front.
Yeah, it should benefit both buyers and sellers by setting clearer expectations and hopefully reducing those nasty surprises after signing.
Absolutely. It's about building a more informed marketplace. But as we've discussed, it's not a silver bullet.
Definitely not. While it's a fantastic framework, it absolutely doesn't replace your own thorough independent due diligence in getting professional advice. Property is complex. Informed decisions are always the best ones.
So whether you're buying or selling, our strong advice is always seek specific independent legal advice from a solicitor and get practical advice from your real estate agent too.
And for general info, those government websites are a good starting point. QLD.gov.osler disclosure scheme is the main one, and the general property buying selling info is also useful.
We'll link those. Okay, one final thought to leave you with.
In a world where systems like this are increasingly designed to bring information out into the open, how much responsibility should still rest on us as individuals to dig deeper, to question, and to truly make sure we understand the full picture before making such big decisions?
Something to ponder. Thanks for joining us on The Deep Dive.